Hi, it's another video with Law and Lawyering Unplugged. I should change that name, it's tough to stumble over. Did a video, my last video, with how to take in a case, how to look at it, essentially how to defend the client using her own words, her perception of the lawsuit, and you go down, as I say, there's usually 1 to 10 paragraphs in a basic collection lawsuit, and you put true or false on the end of each paragraph. Generally, it's going to be inundated with all false, and then you look at from your viewpoint as to the proof that they're providing, very little, and that there exists. You talk about that with the client. And the reason why you have that conversation, and yesterday I talked about connecting to the client, connecting to the case to win this case and get the debt eliminated, is you're creating the most important document in a collection lawsuit that in a lot of cases is statutorily mandated, or if you don't bring that affidavit, it's assumed that you owe the debt, and really the case, if any smart collection attorney is really on their game, they know the case is over and they can just push the court to say, here's how much we think they owe, because the proofs are already assumed because she did not counter with her own affidavit. So let's start. Why is the counter affidavit important? Most collection lawsuits are brought with a counter affidavit. Why did they do that? Because the contract that they're alleging was breached, or the cardholder agreement, it's generally 9 times out of 10 a cardholder agreement, that the debt collector will say, hey, she took out this debt, she lives a certain place, she used the card, she breached by not paying, she owes us X. We own it, the debt, and have the right and have the standing to sue her for the money because she signed this contract. Rarely, I'm going to say 1 out of 10 times is there a contract attached. In some states it'll say, we don't have to show you the contract, we just have alleged, and that's the statute, we just allege that the defendant has it in their possession. 99 times or 100 though is they attach an affidavit from the debt buyers or the debt owners accounting department or bill of sale department. They make stuff up and they have an affidavit. When an affidavit is attached to a lawsuit without a contract, it is generally an account stated lawsuit, which is a definition of a collection lawsuit. That's where stuff at the very beginning is required, that the person being sued. Now, one of the reasons I'm doing these videos is I can see that there's a large landscape now of help for people to do their own lawsuits. I recognize, respect, and think that's a good thing. However, services like Solo Suit and things like that, think if they send you an answer, that's all there is. That's actually critically false unless they are telling, depending on the jurisdiction, you that you have to file a counter affidavit. I don't see that in Solo Suit's defendant answers. A lot of my clients are, after they got involved with Solo Suit, I'm just telling you how it is. There's a good thing for everything. I respect Solo Suit and their business model, but a lot of my clients come to me because Solo Suit told them what to do, but then didn't tell them what's going to happen. And if you go into some of these lawsuits defending yourself through a Solo Suit, and I'm using Solo Suit just by example, you may be in a world of trouble if you didn't add, in this case, a counter affidavit, because the counter affidavit counters their burden of proof shift to you. When an affidavit is attached to a lawsuit, generally that burden of proof that we all share in America, the burden of proof is on the person suing us, the burden of proof is on the prosecutor. That's everything. The burden of proof. That's the bulwark or the wall against the end of due process. Make the other side prove it rather than just say it. It's the genesis, the very basis of what I do with the many fragments of bill of titles and phony collection affidavits. So once they bring an affidavit, and they do and they will, you have to have a counter affidavit. And I don't see solo suit emphasizing that. So a lot of my clients come from a solo suit, if you will, victims, because the minute they go in unrepresented, they will file a summary motion saying she has not denied it, there's no counter affidavit, the law of account stated says burden of proof, she hasn't disputed, yada yada. So let's talk today about helping solo suit, helping attorneys, helping you with the counter affidavit. I'm here to help, not criticize. The counter affidavit is created by you and your client after going over the lawsuit with the client. You're creating an answer. But I have spoken a lot with you to say, don't just say deny, admit, I don't know. That's a solo suit response. And they're doing what they're doing, and it's better than not answering. So I understand how important that is to not answer, avoid a default, and sometimes you just want to get some time to maybe make a settlement deal with the guy suing you. That ain't happening in my office. That counter affidavit is a lawsuit in itself. I will take the answer after discussing with the client and put it into a counter affidavit. The judge's clerk that receives a Parker answer or your answer after looking at my website or going through these videos loves it. They love a decent defense. They love a counterclaim. They love explanation why your client disputes it or doesn't know it, or the assignment's all effed up, because they don't want to default people and they want to give both sides their day in court. That's their constituents in their district. But they, and this happens all the time, I know this to be true, clerks call me and go, wow, you did this, no one's doing this, and they sort of start engaging me like, hey, tell me why you did this. Like, it's a fruit, they're looking for knowledge, and that's okay. Why is it okay? Because that's how the court gets its information. We talked previously about gatekeepers. The court clerk, the judge's clerk, he depends on her or him for his information from the outside. So if you're turning on the court clerk, and you are with this unique approach, they tell the judge, now this stack of, oh boy, collection lawsuits, I got to do 5 Midland credit, I got to do 16 PRAs. This happens. I'm going to tell you from practicum experience, my stuff gets over here. Now, I used to get pissed about that. Why? Because I would probably be the last one to go. It happened again and again. It's an 8 o'clock hearing, it's 10:30, I'm still there, and I'm watching silly stuff go ahead of me. And then they would get to me, and you could tell the judge is into this, has read the stuff. So you want to call attention to your defense and claims by having a decent counter affidavit that breaks down your defense. It's your chance to speak to the court. And you take the other side's, and I always preach this, use the other side's information and plonk it right into your affidavit. You can do anything you want. It's an affidavit. You're showing why. You're saying to the court, that's a fill-in-the-blanks complaint. They got my name wrong. They got my bogue on them. Beef, man. Just nail those guys in your affidavit, because the judge just speaks through its orders. Parker's clients speak through the affidavit, and it is noticed. A counter affidavit is also the basis of a counterclaim. You can make money if you do this. When I say make money, you're going to eliminate a wrongfully brought lawsuit. You're going to get an attorney fee to the attorney, so you don't have to pay him as much, if anything, depending on the case. I take a small sum under $10,000, and then a little bit more if it's over 10,000 because they fight me a little more. But that counter affidavit is everything. Number one, the burden of proof that's shifted onto your poor client's shoulders, and they're like this now. Suddenly they can stand up straight again. I need to do that more. Because you've put the bad guys on their heels. Just put yourself on your heels a second. You're almost toppling over. That's what happens when you get sued. When a client gets sued, they get put back on their heels. It's a fight thing. If you are fighting, and I got in a lot, and they're on their heels, you can finish that quickly. This is what you're doing legally. You're legally putting them on the heels and then maybe pushing them down. And we've talked also as far as examining trials, how you move them along, and then dip. So the trick is the actual statute that they are suing you. Check this out. This is such an attorney thing. They go under what's called an account stated statute. I don't think any of them have read it. Reading is fundamental, they used to say. Reading is in an oasis these days. Nobody reads. Everybody's on their phone or everybody's on ChatGPT, which has its place, but the hard work cannot be replaced. You can't half-ass this stuff. And you don't have to do much work if you just read the statute they're suing. And sometimes I'll read a statute that I've been practicing under for 30 years. I go, it says that? I'm a dummy. Why didn't I? So I'm giving you my dummy mistake to go and just read the statute. So if you point out to the judge, hey, the statute specifically says this, they're not doing that through your counter affidavit, you just won. It's that easy. And they don't read the things they sue you under. And the account stated statute generally says, got to have an agreement, use of the card or whatever it is, and you paid money to the guy suing you. That's generally what states account statute. I rarely see anybody pay a debt buyer money. Usually they get information from a debt buyer and go, what is this? I don't know who this company is. It's already over. The case is over at that point. It's too easy, but you got to put it in your counter affidavit. So cite the fact there's no payment, no agreement, don't even know who this guy is. And say that, I dispute owing this company. Remember, you may owe the debt. You don't owe it to this company. That's as valid as not owing the debt. Someone can't just come in and say, well, just trust us, you owe us the money. It's as valid as you not owing the debt is not owing to somebody else. And the beauty of being sued, and I will never counsel clients on this, you want to be sued if you owe a debt. It's a weird thing I'm saying, but once they sue, they take on a burden of proof now, this large mountain they have to climb to prove you owe it. So they're essentially helping you get out of a debt that frankly you don't owe them anyway. Now stay with me, that the credit card company has written off and made money from charging off your debt, but then has sold the rights to it somehow and got money back from the guy they sold it to, who's going to come after you for the full amount that's been charged off or used as a tax write-off down the road. I mean, we're American citizens. We get jammed like that all the time. We're at the bottom of a large abyss. Up on top, they've made charge-off and tax write-offs of monies, and that's the fact. So I have no conscience or guilt about making someone that isn't being truthful. At the very least, it should be, John owes $10,000. It got written off of $3,000 by Citibank. We only paid whatever for it. There's also a tax profit loss, and then blah, blah. And we also sold it secured trust. Securitization again, hello. They sold it to a trust and got a gob full of money in their pocket and the fees of servicing. That would be honest truth in lending lawsuits. I would love the truth in lending lawsuit where it really has to break down exactly why you owe the stuff. That's another fight. Look for what collectors do in the lawsuit review. The account stated account affidavit is you look at the lawsuit, figure it out, go to your client, and he or she cannot say anything but the truth in an affidavit. I frame it so it has to be notarized either through a federal statute or in some cases I'll tell them to go to a notary. I didn't do that during COVID. I didn't want anybody getting COVID. So there's a federal statute where if they say certain things, and then you will see, it says, upon oath, verifies, certifies, declares under threat of perjury, federal courts will accept that as a notarized, if you will, statute supporting the truthfulness and veracity of what you're saying. Debt collectors try to have their cake and eat it too. So they'll say, hey, this is a breach of contract case, but it's also an account stated statute. They'll mix and match so they have this large umbrella and nobody's asking any questions. That's what I do. I ask the questions. Drives people crazy, debt collectors. The case identifier is a place where you can go. It's not a wall, it's another brick. But if they say it's a breach of contract, but they use the case identifier for account stated or general civil instead of, at least in this state, and I think Florida, CK is contract, breach of contract. Then they've already admitted themselves it's not a breach of contract case. So there's lots of little bricks to make that big wall we always talk about. You review the lawsuit with the client. You ask them what's true and false. You then specifically get into assignments. There's always assignments. Ask the client, do you see your debt and account number passing with this assignment? You don't, you won't, they can't. They'll make up some Excel spreadsheet with lots of redactions claiming, there it is, with no signature. Just as an affidavit must have signatures, so must the chain of title and bill of sale. There aren't, or they're unauthorized signatures, or there's some electronic thing you can't read on the wrong date. But all that stuff I just said right then goes into your counter affidavit. They had the wrong date. That was the wrong signature. You're arguing your answer in the form of an affidavit, which will then be part of your answer, which you will quote in your answer, which you will quote in your counterclaim. The genesis of this whole thing, of my whole practice are two things. The counter affidavit, the assignments, baby. You've heard me say the assignments, baby. It's also the counter affidavit, which memorializes your entire defense. Make sure it is true, because you may down the road be deposed, your client, who's going to, hey, you wrote this, what did you mean? And that's where I want to get into something. I am pushing into securitization. That's finding its way into my affidavit. What the hell is securitization is something a client might say to me. So I give my clients a primer on securitization. I do not want them signing something. I will present to them what a securitized credit card is, and it's just like any other thing you're educating. You go, they're like, that is going on? I said, yes. Now please go do your research. They'll do the same research I Google, and they'll see this concept. So I'll make them read a primer, then I'll present the actual, let's say, Citibank documents. So I'm giving you two samples on my website, collectionstopper.com. The first sample is Shazam. Here's the first sample, and that's a debt buying affidavit. You can see I've been very clear and specific. I name the case. I say I don't owe this debt amount to Calvary. It's against Calvary. I mention securitization and asset-backed securities. Then in the second page, you'll see, second page of the affidavit, where I break down the bill of sale right into the affidavit. And in this case, they've got some issues with what are called, I've mentioned previously, data extensions. If you don't have the right data extension, so if you have a bill of sale that says, hey, the actual debt of the client is in this long address, and then the data extension is XYZ, and then you look at the piece of paper that they're talking about, and the data extension is wrong, that's not a debt of yours in something. The data extension is everything. It's like, just imagine if your name is bobsmith.com and someone's trying to get a hold of you bobsmith.net, they never get a hold of you. It's that critically important. If you're going to use it as evidence, it's got to be precise. It isn't. So I put it right into the affidavit. I put everything like we're having a conversation. This is wrong, this is wrong, this is wrong. I have a conversation because guess what? An affidavit really is. It is the person signing, speaking to the court. As long as in the proper form, that's how you speak to a court if you're not going to show up. There's specific statutes that said, hey, we can prove as a custodian of records, client owes debt, and the statute says as long as it's certified under oath and there's personal knowledge, this piece of paper eliminates the need for flying some guy from New York for Citibank to argue in my silly debt collection case. So talk to the court for your affidavit. And my second affidavit sample is specifically against JP Morgan, and that's heavily securitized. I sat with the client, and if she didn't get it, it wasn't going in my affidavit or her affidavit. She got it. I gave her a primer. I then attached the primer, it's a 2-page primer, to the affidavit. So the court can go, okay, what's this securitization? Always be closing, always be teaching, always think about cases in order. I'll be in front of that judge a year from now. She will know securitization. And it's a thing. I remember when I started doing this 30 years ago, judges would laugh at me doing consumer protection work. Aren't there any real cases for us to talk about today? Today, it's probably one of the highest filed, especially with debt collection lawsuits. There are hundreds of thousands of these, and consumer protection is not laughed at anymore. Other attorneys used to laugh at me because I'm a consumer protection attorney. I wouldn't tell people I did consumer protection. I go, oh, I'm a civil litigator. I try cases. Now I'm very proud of what I do, and the work I do produces happiness. So the affidavit, and take a look at those 2 samples, will show you the assignments are bad, the chain of title is bad, and your client is signing off on this, but I will not let them do that unless I hear that they understand that. It's your job, or if you're representing yourself, to be educated, or the attorney to educate you. But one of the reasons I'm doing this is because people are coming today to me fully educated. They've read my stuff. They've gone online. I'd say 30%, I always have these percentages, but I'd say 30% of my clients have already answered their own lawsuit or are heavily involved. I had one where the person has 5 lawsuits she's handling. It gets to be overwhelming, so I'm stepping in and fixing it all. And when I say fixing, I'm not being condescending, it's just that I have to do it my way for best results for my clients. I'm going to try to keep this under 30, and I'm going to. Your affidavit is your opportunity to do what I always preach. Always be closing. The court, if it separates your file from the others, and you can just see it, whether it's Zoom or you're just standing there, it used to bother me. I'm like, oh, shoot. But now I know that the court has taken extra effort to see what's going on, because the pile next to it of 30 cases, which they're just going through, they've taken the time, and now I'm educating the court for my next case, and I'll become known as the securitization guy, and now I'm an expert. And all I'm doing is reading. So you and your client go through the lawsuit. The more you go through with your client, she will get more knowledge, because she's coming at you from a very nice place. She's like, yeah, I took the loan. Or in an ID case, yeah, my husband did it, and she put it in my name. I just wanted the whole thing to go away. Most clients are coming at you, I'd say not 100%. Look, what can I do to eliminate too big a problem, blah, blah, blah. When I'm done with them, they're laughing, and they're not going to pay a thing over there because they don't have to. And it is all about the affidavit. So, I'm going to end this now, quicken this along. So, look. The counter affidavit is everything. My website at collectionstopper.com with Podcast Plus has enormous amounts of counter affidavits in Word for you to adapt. There may be one there for you that meets your facts. There's so many. So attorneys, use that for your clients. Clients that are handling the cases themselves, have at it. Be advised, do not answer a lawsuit without a counter affidavit. The one exception to that is if the other side has not brought a contract, your originally signed contract, or has not brought an affidavit, which 99 times out of 100 they will bring, you generally don't have to do a counter affidavit. Here's Parker's rule. Always do a counter affidavit. Why? Because you're arguing your case. Never miss a chance to make a good first impression. This is the first impression. So what's a good first impression for you? Admit, deny, don't know, admit. Or, hey, the lawsuit is broken. I dispute I owe it to this person. They don't even have the right name. I don't live in Warren, Michigan. I think this debt was securitized, so I went online, and it turns out Citibank securitizes all their debt. I'd just like to see an assignment from the trust back to Citibank. After Citibank, by the way, made 80% of the dollar it's getting from me back from the company, the securitized trust that bought my debt, that has to own it to get it off my bottom line so I can get better, blah, 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 blah. That goes into your affidavit. Attention getter, hello, blue light special. That's why the file gets separated. That's why the file gets extra attention. People don't like extra attention. Yes, you do in this case. Because the only thing, the judge isn't going, wow, the plaintiff debt collector wrote a brilliant opus, because it's 5 schlocky paragraphs of no proof. See the last video I just did about how to handle debt collection lawsuits. Yours is a genuine page turner that needs to be a movie. I'm serious. Like this. Here's the movie. Be the author. Be the writer of your destiny. Just a little time and trouble will win you cases, will save you money, will get a debt collector off your back. And that's it. We all have a cloud over us for some reason or another. And as I argue in my How to Take a Debt Position video, it's all about control. When you slam them with the counter affidavit, the guy's first job out of law school or last job is like, what do you want? He just wants to punch in at 9 and get out at 5 and not take this job home to him and his bourbon. So cause a little trouble. Remember, I'm the problem maker. This is the problem maker. The counter affidavit is everything. It's all about the counter affidavit and the assignments, baby. Defense, boom. That's what this does. So go out there, use this information. We will get this done for you. Subscribe, like, comment. If you want a video on something, touch my tempo. 30 years, I'll give you 30 minutes. I'm under 30, I'm gonna finish this. But please subscribe, make it available for everybody, make everybody happy. This is all free. Go to my website. Tons of free stuff. Who doesn't like free? All right. Thank you again. Have a great day. Let's do this together.